We are at a moment of extraordinary transition in Europe's political and legal handling of asylum. For decades, the cornerstone of refugee convention protection has been the 1951 Refugee Convention, the Geneva Convention, and its later protocols, interpreted expansively by national courts and by the European Court of Human Rights. But the political winds have shifted. And only a few years ago, Angela Merkel's open-door policy during the Syrian refugee crisis defined Germany's moral leadership. Today, Merkel's successor, Friedrich Merz, promises tougher rules, even stripping automatic legal aid from failed asylum applicants. This is not an isolated stance. Across Europe, governments are moving in lockstep towards restriction. Hans-Jürgen Papier, Germany's former top constitutional judge, recently sounded the alarm. He warned that uncontrolled and unconditional immigration undermines public faith in democratic institutions, and that overbearing court judgments on asylum have become, in his vivid phrase, like mildew settling over the powers of states to act. It's a stark intervention from a man once charged with defending fundamental rights. And the political context is equally stark. Far-right parties now top polls in Germany, France and Britain. AfD leads in Germany, and oddly there have been some deaths among AfD leaders. Le Pen's National Rally in France, Nigel Farage's Reform in Britain. This electoral surge is powered in no small part by public anger over migration and asylum policy, and Europe has shifted from debate about humanitarian generosity to existential questions about whether democracies can govern their borders. Meanwhile, Britain's own policy is descending into makeshift improvisation, hotels full to capacity, now the proposal of warehousing asylum seekers in industrial estates. This legal battles over sites such as the Bell Hotel in Essex show how local authorities, courts and ministers clash in a muddled system. It's costly, incoherent and politically unsustainable. And we need to recognise Britain has missed its chance to lead this debate. 3 years ago, under Rishi Sunak, it could have acted. Instead of proposing an international settlement, we were content with small boat slogans and a doomed Rwanda scheme dreamt up by twits in the Home Office. The opportunity to shape global consensus was squandered by insularity. Yet the need for an international conference is greater than ever. The current system rests on assumptions from 1951 that most refugees flee war zones into neighbouring safe states, that numbers are modest, and that relocation can be handled at national discretion. None of this holds true today. Asylum has become entangled with mass economic migration, with smuggling networks, with legal activism that stretches definitions beyond recognition, and the result is paralysis. Democratic governments stripped of their ability to act decisively, public in different countries losing confidence, courts accused of overreach. So what should we do? Well, first, we have to recognise that this sort of insular parochial approach, championed by absurdities like Suella Braverman and Priti Patel, doesn't work. And for Yvette Cooper to continue that line is to continue down a road to madness. We need to convene an international conference. Whatever we do needs to be internationally sanctioned. Call it Geneva II, perhaps. Its aim to clarify the scope of asylum rights in the 21st century, to balance humanitarian obligations with national sovereignty, and to agree mechanisms of burden sharing so that the weight of taking in asylum seekers and migrants doesn't fall exclusively to people in the lower part of the European continent, so that all countries share this process. Offshore processing, resettlement quotas, expedited deportations, all should be on the table. And this should be a conference which is attended not only by Europe and Britain, but also by the neighbouring states who have skin in the game. Albania, for example. Secondly, we need to distinguish between genuine asylum and irregular migration. If anything counts as asylum, if everything counts as asylum, then nothing does. By tightening that definition, we preserve the integrity of protection for those who truly need it. Thirdly, we need to rethink the role of supranational courts. If judgments are consistently viewed as obstructing democratic choices, then the very legitimacy of the European Court of Human Rights is at risk. Reform is required not to destroy its authority, but to rescue it. And the danger is clear. If mainstream governments fail to grasp this nettle, the far right will. And that is why it is not enough to tinker at the margins with warehouse accommodation or ID cards. The issue has outgrown national patchwork. The call to action is simple. Britain, Europe and our allies must now take leadership. And indeed, America, I'm sure, would be joining this, and Canada. It is time to convene a new international settlement on asylum before the political foundations of liberal democracy crumble under the weight of inertia and stupidity.